was shocked that in fact California got this information about donors, that they knew that charities, they could demand charities provide information about who their donors were. I assumed that was, protected information.
And as is so often the case for us, we were the last resort, right? The client had gone back and forth with California for several rounds saying, please, we have serious concerns about protecting our donors. We've made commitments to our donors that we will not be disclosing their identities to any state such as yourself. We're standing on our First Amendment rights. Is there some way that we can resolve this?
And I remember very early on having a conversation with you, and you said, I don't know if you remember this conversation, that this thing's going to end up in the Supreme Court. That was your prediction from day one.
For us, it was important in terms of the legal principles for the client to the end result, and they, of course, wanted everyone to win from this case. Once they had to make the stand, they didn't want it to be just about Americans for Prosperity Foundation. We really had to carry the larger banner for all charitable groups that could be subjected to this demand, and the question was, how can you kind of build towards a precedent that would have that broad protection?
And to your point about winning for everybody, ultimately, of course, the NAACP, the ACLU, other groups that have stood for the associational principles for decades, they all joined us in wanting to contest the California decision, and at the Supreme Court with their amicus briefs, et cetera. So, I mean, it really did end up being something that was a much broader victory for, I think, all associational rights.
We had an expert, Paul Shervish, who talked about the importance of donor anonymity really across the board for organizations and across the political spectrum.
We, of course, won the trial, and that was after your great summation and all your great work as well with witnesses and sort of running the whole show. And then we went on appeal, and not unexpectedly, I think to us, we lost.
There were a lot of people who it was, again, very gratifying. They'd supported us in the case. There were a lot of amicus briefs we got in front of the Ninth Circuit, including it was the NAACP Legal Defense Fund who filed an amicus brief that we were very proud of and grateful for. We still had a lot of work cut out for us. We still wanted to keep this great amicus coalition going, and that amicus coalition expanded. We got more and more states that were coming in on our side. We had a lot of organizations that had been very thoughtful about these issues. Each brought their own perspective and their own kind of arguments, and great authors of these amicus briefs. But that came in at the cert stage, and it was very helpful, I think, to our chance. I don't remember seeing the sort of outpouring that we had in terms of the number of amicus briefs, how impressive they were, how many joiners they had, and how broad the coalition was. I think, judging from the reactions in the wake of the decision, I think all these groups, all these individuals have been so supportive of us. They were gratified by this result, and they knew that they won this thing with us, which is exactly what we were hoping for from the beginning.